All right, let's talk about something that gets really confusing really fast. Self-defense laws here in California. We're going to cut through all the noise and tackle one of the biggest questions we get. Are batons actually legal? Let's dive in and get a clear answer.
You know, personal safety is one of those things you just don't think about until you have to. Picture it. You're walking to your car late at night, it's dark, quiet, or maybe you're out for a jog super early in the morning. 99% of the time, it's totally fine. But in that one split second where something feels off, suddenly your safety is the only thing that matters in the entire world. And that's a moment none of us want to be unprepared for.
So when you're thinking about a self-defense tool, a lot of people want something that's not lethal but is still effective, right? Something you can actually carry with you. And that's where the telescopic baton comes into the picture. It seems like a great option, but man, the rules around it in California, it's been a huge mess of confusion. Okay, so what's the big deal with batons anyway? Why do so many people look at this particular tool for that extra peace of mind? Let's break it down.
Look, most folks aren't trying to buy some fancy $1,000 collector's item to display in a case. They want something that just plain works, you know, something practical, something reliable. Batons are great because they're compact, they're easy to carry, and with just a flick of your wrist, boom, it's ready. That's exactly the kind of simple, no-fuss tool you need when things get real.
All right, now let's get right to the heart of the matter, the legal stuff that's so confusing. For forever, basically, the answer to can I have a baton in California was a hard no. Simple. But then, a law that's been around for 100 years got completely flipped on its head. So here's the deal. Since 1923, for almost a century, California Penal Code 22-2010 has been on the books, and it flat out banned possessing what it calls a billy. That's just an old school legal term for a billy club or, you guessed it, a baton. It was a very clear, no-nonsense ban for a very, very long time. But then, 2024 happened, and everything got shaken up. On February 23rd, a federal judge in a big case, Fouts versus Bonta, looked at that century-old law and said, nope, this is unconstitutional. Huge news. But wait, it gets crazier. Just 3 days later, the state of California turned right around and filed an appeal. And just like that, the entire law was thrown into this weird legal limbo. So, what does that mean in the real world? Well, right after the judge's decision, the California Department of Justice had to send out a memo to all police departments and law enforcement agencies. And there was a super important phrase in it: enjoins the enforcement. Basically, the court put a stop to things with something called an injunction. So what on earth is an injunction? The easiest way to think about it is like a giant pause button. The law itself, that Penal Code 2210, it's still technically there. It hasn't been wiped off the books. But what the court order does is it blocks the police and prosecutors from actually enforcing it while the whole appeal gets sorted out in the courts. Okay, a law is paused but not gone. What in the world does that mean for you, for the average person who just wants to feel a little bit safer? Okay, here's the single most important takeaway. Right now, as of this recording, the statewide ban on having a baton is not being enforced. That's what the injunction means. But, and this is a huge but, that absolutely does not mean batons are now 100% legal everywhere in California, forever, no questions asked. This whole situation is temporary, it's in flux. So, this leads directly to the questions everybody's asking. Okay, so, can I keep a baton in my car? Can I take one with me when I'm jogging? And the honest answer is, well, it's complicated. And here's why you have to be careful. So first off, even though the state ban is paused, that appeal is still active. The court could reverse the decision, and poof, the ban is back in full effect. On top of that, this is just the state law. Your local city or county could have its own set of rules that still apply. Private property owners can also restrict what you bring onto their land. Oh, and this doesn't change anything for security guards. They still need their official BSIS baton permit. See? It's definitely not a free-for-all. So with all this legal back and forth, the best thing you can do, the only thing you can do really, is be smart and stay informed. So let's just boil it all down. Here's the bottom line. The legal ground under our feet is shifting. What's happening right now might be totally different in a few months. That means it's on you, it's on us to be responsible. You absolutely have to check the current laws, both state and local, before you even think about buying or carrying any kind of self-defense tool. And that kind of leaves us with one final big question to think about, right? In a world where the rules can change so quickly, how are you going to prepare to protect yourself responsibly? It really forces you to think about your own personal safety plan, because knowing the rules and staying informed, that's always going to be your first and most important line of defense.
Thank you for trusting us with your safety. Visit selfdefenseproductsllc.com.